Hello and welcome, everyone. I think we are about to get started. Oh, yes, that is very important. First things first. Good job, Daniela. Leave a like and a subscribe if you haven't already. So, yes, let's just take care of business right away. And good morning. Good morning, Alyssa and Colleen and Kel Marie. Oh, there goes our prosecutor. So I don't know. We'll see if they. And Golden Girl. Tell this, everyone. Ooh, who are all these people coming into the courtroom? Ooh, we got an ahoy. An ahoy hoy. I wonder who all these people are. And Naomi, good morning. Well, Court TV is just a tease. They got me. They switched off of their seal of the state of Florida. But so, Julia, are you watching from your office right now? Is that what you're telling us? It does kind of look like they're coming out of the bathroom, doesn't it? Out of the bathroom, into the courtroom. Yeah, Court TV kind of made me think that we were getting started here. But let's see, what time is it? No, 6 o'clock, right on the dot here. So let's go. Come on, let's be punctual. Second. Do I have court today? No, I don't have court today unless I get a call to the contrary, which could happen, but I doubt it. No, not always. There's not always a time limit on closing arguments, but maybe there should be. Oh, okay, prosecutor's there. Man, Court TV, I had time to go get. I had time to go make breakfast. So, Now I want to know who all these people are. I mean, it's got to be just family and friends, right? Okay. All these people that are coming in, like, we don't need you. We need the, yeah, we need the defendant. We need the judge. We need the defense attorney. We already got at least one prosecutor, so we can get this thing started. Let's make it happen. Oh man, Court TV tricks me. I had time to make eggs, for crying out loud. Oh my goodness. Where are your priorities? Good morning, Sheila, court reporter. Go make eggs. Go make my eggs. Fine. Fine. I'll go make eggs. Or should I have another bagel and cream cheese. Or should I have eggs. Eggs in a bagel. All right. All right. All right. All right. We got time. Okay. I'll figure it out and I'll let you know.
All right, good morning, everybody. We're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I have both the state and the defense here along with Ms. Benefield. Is there anything we need to talk about, state, before I bring the jury out?
No.
Mr. Taylor?
No, sir.
All right. Are you ready? Are you ready to go? Do you need another minute or are you okay?
I'm ready.
All right.
Thank you.
Well, let's go and bring the jury in. All right, y'all can have a seat. Good morning, everybody. Welcome back. Before we get started, did anybody talk amongst yourselves about the case, discuss it with anyone else, or do any research on it about the case? Nobody says no. All right, when we were finishing up yesterday, the defense had rested its case. The state, if it wishes, can present a rebuttal case. State?
Judge, just very briefly state and call Eva Benefield.
You solemnly swear or affirm the testimony that you give will be the truth, the whole truth, and nothing but the truth.
Ma'am, same rules as last time. Just make yourself comfortable. Get about 12 to 15 inches away from the microphone.
Good morning.
Good morning.
Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
And when was that picture taken?
That was taken in 2018.
And then I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this picture taken?
That was August of 2020.
And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
And Judge, I just want to publish it briefly. Oh, at this time, I would enter State's Exhibit 105 into evidence.
Same objections?
No, no objection.
No objection. Proceed.
I don't know why. There. Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
You can cross, Mr. Taylor.
No question.
Can the witness be released from her subpoena?
Yes.
Can the witness be released?
Oh,
Can
we're
the witness
back
be released from her subpoena?
with the
May
daughter.
be released from your subpoena. You're free to go.
Thank you.
Thank you. State.
State has no further witnesses. Thank you.
All right. All right.
Well, that was fast.
Members of the jury, at this point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about three things: listening to all of the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down, now that everything is done, and work on those jury instructions to make sure they're in final form, so that I can instruct you on the law, you can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well.
Yes, Ling, I never heard of
Get
him.
ready for those closing arguments. So my plan is
So
to.
yes, egg on a bagel.
Did anybody want to be heard before?
Oh boy. So what did the daughter just testify to? Any mention of her fish necklace? Well, look who it is. It is Mike Gravelin.
So what I'm going to do is give you a break. If I could have you back downstairs at the jury assembly room at 12:30, and then we're going to get you rounded up and get you back up here and get going with. If you remember, it's going to be some initial instructions by me on the law.
At least there's
Attorneys will
that.
have a chance to give their closing arguments if they wish. Then there'll be some final instructions, and then you'll begin deliberations. So remember, now that everything is done, please remember the rules. Don't discuss the case amongst yourselves until all of those things are done. Don't talk with anyone else about the case. Please don't do any research or watch any coverage about the case. All right, so we'll see you back downstairs at 12:30. Thank you.
Oh, come on, man. I thought we hashed out jury instructions yesterday.
All right, you all can have a seat. As I was coming downstairs, Kelly handed me an email from the state with, I haven't had a chance to look at it yet.
What are they trying to do? Yeah, with
I
this,
do, I have,
show pictures of her dad. Just for sympathy?
all right, so
It's so we can talk. So we can talk amongst ourselves.
I assume that
Does that
this
make
has
power rankings
all
of
of the changes that
cheeses
we discussed yesterday.
and song dedications?
So let's go ahead and take a run through these. And Ms. Benefield, please feel free to
Some people
share a
might have
copy
careless
with
whisper still
your
stuck
attorney,
in
look over his
their
shoulder.
head from yesterday.
So, Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections, additions, corrections, deletions, please voice them. State, even though you prepared them from the standards, if you have any objections, additions, corrections, or deletions, please let me know as we go.
Yes, sir. Thank you.
All right. First, 3.1, any objection?
No.
3.2, statement of the charge, any objection?
No.
7.1,
maybe
introduction
manslaughter.
to homicide,
She's just charged with murder,
Justifiable
secondary murder,
inexcusable.
and so we'll see. Oh, crazy dedicates.
No objection.
You think he's a rock star?
You have to, the second part. Under great bodily harm,
So yeah, we got to figure out how the jury.
means great is distinguished from slight, trivial, minor,
That's
or
a great
moderate
idea.
harm, and as such does not
We did
include
sing
mere
Tainted Love.
bruises. I object. to
Mike
that.
is welcome to come on and sing
I
Tainted
think
Love with me.
particularly because of the nature of the facts in this case.
Give the people what they want.
State.
It's a standard jury instruction, Judge. We'd be asked that it be read unedited.
Specifically, Your Honor, because of the unique facts of this case, that is to say, relatively minor bruising leading up to the crescendo of the actual event.
Wait, what is a
I think
mankini?
to
I don't know what I'm
keep
down
this
with that.
instruction as it is to the distinct detriment of Miss Benefield, because it's basically telling them that they can overlook what precipitated the final incident.
No, I'm not.
All right. I understand
That was
your argument.
Never.
It is part of the standard
Where
jury
that
instruction. It's not misleading in its nature. In describing great bodily harm, it complies with Florida law and the statutes. I think it needs to be given as part of the standard
Run
instruction.
away, I've got
So I'll
to
overrule that objection.
get away from the pain.
Other than that one,
Right.
the rest of it looked all right.
Through the
Yes.
heart of me.
7.4, murder in the second degree.
And it's the state's position
Yes.
that part in yellow about such
Keep
provocation.
dreaming is what I would say.
Judge, I'm sorry. I just wanted to also mention in the May update to the jury instructions, they cut out the reference to mere bruises.
No, well, online, it still has on the,
Do you have the
Once I
Florida
read
Supreme Court
you.
order on that?
I guess Singing Tainted Love better put when they're describing their relationship.
No, defense. Do you have there'd be a Florida Supreme Court order. Do you have that?
I do not have it with me, no, but I believe that it was removed from the May update. I may have it, Judge. Give me 1 second.
Yeah, I'm gonna have to see it. The Florida Bar website still does not include mere bruising.
Okay, here, Judge.
Well, can you show it to the state first?
well, this is a different instruction, sir. This is not homicide. This is justifiable use of deadly force. That's a different instruction. That's the one that was updated in May. Murder, the introduction of homicide was not updated in May.
This is 3.6F, justifiable use or threat.
No, but yeah, I'm with David there, Colleen. We need a little clarification on that last statement.
We'll note that mere bruises has been redacted.
All right, thank you for letting me review that.
Just to make sure we're clear, the old version of self-defense read exactly like the new version. It wasn't taken out in 2024.
Well,
That
Mike,
was not the parts that were amended.
doesn't your ex live in Florida too?
On 3.6.
Let that sink in.
All right. Again, I appreciate the argument. It's a standard jury instruction. It's not a
He
misstatement of the
did
law.
punch a dog unconscious
I'm gonna
and
give the
throw a
standard.
cat down the stairs or against the wall or something like that.
All right, 7.4.
It's okay.
And Judge, it's the state's position that there's been no evidence of sudden provocation. I'm sorry, heat of passion, inadequate provocation. There was no evidence that a reasonable person would have lost normal control, would have been drunk. There was no evidence of a blind and unreasoning fury, so the state would ask that that section be removed.
You leaving us, Slinger?
Do you want the
Bye.
sudden provocation?
Hopefully we see you back here soon. We'll be here a while, I'm sure.
Towards the bottom of 7.4, going to the second page.
It's the yellow part.
I'm fine with it like it is.
So you want it in,
Yes.
and state you want it out?
Yes, I don't think there's been any evidence that entered to go to those facts. That portion.
Welcome, Spork. Let me check Colleen if he answers my text. Actually, let me see.
All right, I'll leave it in. Three point three D, possession firearm.
Fine.
State.
No,
3.4, lesser included.
Fine.
7.7, manslaughter.
Fine.
3.3A, aggravation of manslaughter with a firearm.
Acceptable.
All right, 3.6, justifiable use of force.
Yeah. Which one? Yeah, two small tweaks.
I'm sorry, which instruction are we on?
3.6F.
Oh, okay, that's what I thought.
Whether if the court would consider under the second part, giving an instruction on imminent, what imminent means. The instruction as is reads, the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real. We could provide to the court a definition of imminent, but we'd like to have it.
All right, do you have it? Do you have a proposed jury instruction?
I'm not prepared at this point to tender it to the court.
Well, this is the final charge conference, so I'm going to need it.
Give me a moment, Your Honor.
Yes, sir.
Okay, here's one that we had, Judge, in preparation. I'm trying to keep up with all the paperwork. Let's do one about-
No, Mike, don't let that. Don't change now, Mike. Don't change now.
Your Honor, I'd also like to request, if we could, adding a definition of great bodily harm in the deadly force definition paragraph.
Where did that definition come from? Immediate.
I think it might come from case law.
It says it comes from Webster's Dictionary. The state objects, number one, that definition does not make sense to the state. Number two, I'm on Webster's Dictionary where it says it comes from. That is not the definition provided by Webster's Dictionary. It's partially, I mean, it's parts of the definition, but the Florida Supreme Court has not felt the need to define imminent. I think imminent is a word that is commonly understood by these jurors, and the state would object to adding that definition or changing the definition of great bodily harm in this 3.6, which I think was his second request, which it's in the second paragraph. Great bodily harm.
Griggsy, would you like to
means
power
distinguished
rank
from
your
slight, trivial,
dictionaries
minor, or moderate
for
harm.
everyone, please?
That second paragraph.
We're not asking the court to change the definition of great bodily harm. We're just asking Your Honor to add it in that paragraph as well.
In which paragraph?
Or
Under
You just wanna
3.6F, the
power rank
second
your
paragraph, where it defines deadly
maybe not limit it
force
to dictionaries. You can just
being
power rank
force
your
likely to
reference
cause
books.
death or great bodily harm.
The very next sentence is the definition of great bodily harm.
Well, it's got a definition of great bodily harm. And actually, my copy has an explanation.
That's the,
Right, it's
that's the standard.
from the standard.
Okay.
And then it was you asked for imminent, you made your arguments against it, rebuttal.
No rebuttal other than I don't see what the downside is to it. I don't see how there could be any prejudice.
Okay. I appreciate that. I've never given a definition for imminent, and I'm not saying my ruling is based upon, well, I've never done it in the past, why would I do it now? I've separately and independently reviewed your proposed definition of imminent. I don't find imminent to be a word not in common usage or understood by an average juror. I don't think it needs to be defined. It's not defined in the standard. So do you want this marked and put in? Because I don't think you read it in. So let me mark it to preserve. So this is defendant's proposed definition of imminent.
What is Kuchen? Kuchen, how do you say it?
Is today the 30th? All right, that'll be filed.
You eat Kuchen with a cake fork?
Judge, I think we got ahead of ourselves in this instruction, so if we could go,
Mhm.
back. Under the paragraph.
Will everyone here know what
3.6
imminent
at
means?
The first page, it says the law justifiable deadly force, use of deadly force is as follows. It's the state's opinion that that first section in yellow would come out because of where it says, but is not relying on 776.0131, which this defendant is relying on that portion, which is the very next portion, and it's almost
Aha.
identical, other than it adds extra things about since she was in a dwelling.
Well, that's what we discussed
Oh,
late
here's
yesterday.
power
so
ranking.
You're in
Okay.
agreement?
Okay.
Yeah.
All right, so
I'm
that,
sorry, Judge, I didn't
dictionary.
realize we made a decision on
The
that.
elements of.
well, I don't think we made a decision. I just rambled on and on,
Happens.
explaining the difference between the
Thank you.
two and the distinctions and why 7760122
Thank you for power ranking
and
your reference materials.
7760312 differed than 7760131, but covered the same ground.
Good morning,
Just
Katie.
one is
Can you power rank
general
your favorite
self-defense and stand your
materials?
ground, and the other one is in your home. And I would think that the defense wants the in your home.
Yes, sir. So I think we would pick up after that law on justice
And
to.
Daniela, what
if
is
she's in a
the,
dwelling, that portion.
Right.
how do you say cake fork in German?
All right, here's where we're going to
Since we don't have,
need to take a few moments to talk about
we just have forks. I don't know that we have.
the forcible felonies. And Mr. Taylor, I had written them down yesterday. Hopefully you saw, oh, there it is. All right, state yesterday, well, let me confirm with the defense. So on the actual self-defense instruction that we're going to use for the 776-013 subsection 1, I assume that you're going to want A and B?
Yes,
Okay. And then the forcible felonies you mentioned yesterday are burglary, felony bat, ag assault, false imprisonment.
Griggsy going the extra
Right.
mile
Are
on
there any others?
power ranking
No,
of
sir.
reference materials.
No felony battery. I thought that felony, did you say felony battery?
Mhm.
Okay, I'm sorry.
That's what was requested.
Yes, I missed it when you just said it, Judge, sorry.
Burglary, ag felony bat, ag assault, false imprisonment. State, are there any of those that you want to agree with before I hear argument from both sides?
No, Judge.
You don't agree with any of them?
Well, I may agree with false imprisonment. I need to think through burglary still. I've been thinking through it for the last 12 hours or 16 hours, but I'm not sure yet on that one. So I just think there's problems with each one of them, and I'd rather if we could just go through them.
Okay. Burglary.
I think it's a classic remaining inside. The testimony, if the court recalls, from Miss Benefield was that when he spun her around in her effort to leave the home and block the door, she summoned the wherewithal to command him to leave now. You have to leave now. That would have revoked his license to be present. And as a result,
Yes, every
at that
subset
point,
would power rank
he was a
their reference
remaining
materials like
inside burglar.
Colleen does. And go Black's Law, Black's Law, Black's Law. In
All right,
that
well,
order, too.
That's not just the end of it. So I've got the standard instruction for burglary, which would need to be obviously modified because I don't instruct them on the burden of proof. It's just the
Yeah.
elements for any of these forcible felonies. The initial portion is going to be the elements of or for the forcible felony of burglary are, and then it'll give the elements. But if you, on the burglary, under 2, there's 2A, B, or C, so I need to know which one of those you're arguing.
Julie, you missed Griggsy's power ranking of the
And
reference
based
materials,
upon what you just argued,
which were
I'm assuming
Oxford
that
English
you
Dictionary,
want 2B, as in Bravo,
yeah, elements of style. And
after it, that would be essentially
what was the third one, Griggsy?
2 would be Doug Benefield, after entering the structure, remained therein after permission to remain had been withdrawn and with the intent to commit, there has to be some
Battery.
crime alleged, right? Because it
Yeah.
can't be burglary or trespass. Or it could just be an offense other than burglary or trespass inside the structure. I need to know what you're proposing.
Battery. Domestic battery with
Give me a
substantial
moment.
bodily harm. So it sounds like, yes, there's a technical legal definition here of burglary. We had this, oh gosh. Fortunately, they changed the law here in Nevada a couple of years ago because before Nevada had a wide open burglary statute.
I think we would prefer other than.
There was no breaking requirement. Burglary was just entering any structure, and I mean any structure.
All right, state, now it's,
with the intent
Ken,
to
are you asking for any
commit
other
battery
portion of the burglary
or
statute if
any
it's
other
to be
crime
given?
within that structure. And it sounds like this is something similar here, that he was in there or he remained there once permission was revoked to stay there in order to commit a crime. So that's why they need to allege something here. He stayed there in order to beat her up, I don't know, or to do something. Yes, because bringing in the forged documents shows that he entered that building with the intent to commit
It's 13.1.
fraud. So as long as you had the
13.1
intent to commit,
burglary.
you have to prove that the intent was formulated like before he entered, but there was no breaking requirement.
Computer problems, Your Honor.
I think the internet just moved back. It was down.
Right, here we go. All right, what was the court's question?
On the burglary
Yes, sir.
instruction. So we've nailed down the elements that you're asking for. I'm asking, is there any other portion of that, before I go to the state and get their argument, is there any other portion of 13.1 burglary that you're requesting?
Judge, are we talking about, I just want to make sure we're talking about the same thing.
Yeah,
Two,
so
A, B, or C?
the court is giving 1 and 2 had permission or consent to enter, and 2 after entering remain therein.
Yep, and then I have to give A, B, or C
Okay,
as appropriate. And I'm sorry, that's A, B, or C, can be in the conjunctive or the disjunctive.
all right, we would request B and C, Your Honor.
All real. Welcome, Kim.
All right, and on C that you're requesting, is it just to commit or attempt to commit a forcible felony,
Yes,
which potentially will be.
you're,
Now, any other portion of that instruction before I go to the state? Or you state, whenever I get over to you, if I do decide to give it, if there's any additional portions you prepared to argue those.
no, that's it, Your Honor.
All right. Okay, that's it, state. So they want, defense is asking for that. Are you looking at the standard for burglary?
Yes.
So it's on the second page.
Yes, sir.
And if I give it, it'll essentially be something along the lines of the elements of the forcible felony of burglary are 1, 2, B, and C. On B, of course, the conveyances would be struck. B would be after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure. C, of course, there'd be an or. C, commit or attempt to commit a forcible felony. So obviously you object to that, but if I am going to allow it, is there any other part of this instruction that you would want to be given?
Two paragraphs. Oh, let's see. It says
We all watched in disbelief there.
the next paragraph is about intent being an operation of the mind. The following paragraph says, even though the unlawful remaining in a structure is proved, and I know we're not supposed to talk about proof, so I don't know how we would word it, but the evidence does not establish that it was done with the intent to commit a crime other than burglary or trespass, the defendant must not be found guilty. I don't know how we would word that because we don't have proof, but I think that is an important.
Good news, I have suggestions.
Okay.
All right, so the state, in addition to what you're requesting for the elements, is asking for those next two paragraphs to be given, which explain intent. And I only had, when I say I have suggestions, this comes up in, I don't want to say every self-defense case, but so many of them, I have language that I've used in the past.
Yes, sir.
Welcome,
All
Skylar.
right. So here's what I propose it would sound like, and everybody can object because you don't want it.
And Arto.
You want it, but might not want like the language. But I've given it before, and it works. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Here's where the changes are because we're not saying proof beyond a reasonable doubt or anything like that. Here's where I've made changes. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was
All right,
done
hurry
with
back,
the
David.
intent to commit an offense other than burglary or trespass, then a burglary has not occurred. That's what I've said in the past. And it's an accurate, I'll hear your arguments, but I've found that it's an accurate statement of the law because the other way is the defendant must be found not guilty. That's not what we're talking about here. So it's just letting them know that what intent is and how that portion of the instruction operates.
Yeah, that's fine with us, Your Honor.
All right.
Well, that's
Do you need
disappointing
that,
to hear,
State?
Katie.
I will need that. And I can say based on the conversations we have, I don't have an objection to the instructions as you've crafted them.
All right.
I just will need to.
Oh, I'm sorry. And we also need structure because structure is not defined in any of the other instructions. And that's on the very next page. All right, Mr. Taylor, what I've done is I took the standard instruction and have amended it in my own hand as I've read. Do you mind if I give this to the state so they can take it back and make it part of the instructions?
No.
All right, thank
Does
you.
that include the elements portion too?
Yes,
Okay, sorry, I was trying to do it
Yeah.
as you were talking, but I wasn't keeping up.
my penmanship is horrible. I
That's fine.
apologize.
This is perfect, Judge, thank you.
Oh, Katie, there's
So that's what I've approved for.
hope
burglary.
still. You can turn.
Let's talk about false imprisonment
into
next.
banana bread.
And that's instruction 9.2.
That's a great question. I don't know.
Judge, I had one thing before we leave.
Oh my goodness. Look at how resourceful everyone is.
Of 3.6F, justifiable use of deadly force.
Don't listen to Beth,
I
please.
wanted to ask the court to substitute
Do not
2
add nuts
words
to your banana bread.
in the final section.
I don't think we've gotten there yet.
Have we not gotten there yet?
Not to the end of the instruction. We're still doing the forcible felonies portion. Yeah.
All right.
So the next forcible felony that the defense has requested is.
You can
false
do hard
imprisonment.
things, Katie. You can do it.
So 9.2. If I give it, again, it'll begin with the elements for the forcible felony of false imprisonment are.
No, Julia, you don't.
So which one of,
Nuts to the banana bread.
those elements or methods by which one is falsely imprisoned do you think the evidence supports Mr. Taylor?
We would like to have confined
See, you can do it.
and restrained.
Make it a banana muffin then, without the nuts.
Just those two?
Yes, sir.
Okay. And also on number one, it would need to read Doug Benefield forcibly, secretly, by threat. Which one of those?
Yes, thank you, Kel Marie.
Forcibly.
No nuts in the banana bread.
So you're not asking for secretly or by threat. That actually make it easier because secretly has to be defined.
How about forcibly and by threat, Judge?
It would be or. And that
Not
means
sure,
we would
Kim.
not need secretly. All right, state.
I think the
State would
consensus
object.
here
There's no evidence of
is
the time in which Ms. Benefield used deadly force that Mr.
she
Benefield
might have been
was
justified,
receiving.
but
If there was a time in which.
we'll see.
there
I found her to
could
be
arguments
convincing,
of
actually. I
false
found her very
it would have
believable
been
when she
She tried to
testified.
get out the door and claims that he spun her around by her arm.
Oh,
But
yes.
there was no evidence that when
Work.
she was in the bedroom, there was any effort to
I agree.
forcefully or by threat.
I agree. And I
bind
see chocolate
or
chunks
restrain her
in
without her lawful consent to
like
the
a
state.
pumpkin
All right, rebuttal.
Well,
bread
actually-
too. Have you ever had that?
I believe the testimony.
Great
was
harvest
that
pumpkin
when
bread
she
with
turned
chocolate
around, he was
chunks.
standing in the middle
Good call,
of the
Spork.
doorway, blocking the exit to the room.
All right, I understand completely that each side has their own theories and thoughts and not versions of the facts, but view of the facts. However,
Yes, she
the
testified.
facts as
and,
presented by the defendant do support the giving of
what was
this
weird is
instruction.
even after the state
False
cross-examined
imprisonment.
her, she was
Here's how
even
to read.
more
The
sympathetic
elements for the forcible felony of
terrible
false
job.
imprisonment are
cross-examining her.
Doug Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. Doug Benefield had no lawful authority to do so.
Yes,
That would be
Yeah,
the
man,
end
I
of that
think probably
instruction.
got a little more accurate.
As I review the rest
You
of
can
it,
believe she was abused.
the rest has to
but there's
do
still
with
a few
certain
things that
enhancements.
don't.
Are you giving me that one too? Are you gonna give me that one too?
I would ask.
If not, I'm gonna need you to repeat it.
Yeah, no,
Okay.
my plan is to,
Hey,
after I do
We love you,
this,
Beth.
give them
We
to
don't
you
have a
because
nut
then it's
loving
all,
chat.
Yes, sir. Thank you.
I'm sorry to put that on you
See what
because
I
I know you're objecting to it, but
It's on her. It's on
all
her.
right. Anything else on false imprisonment? So I am going to give it as I just read.
Okay. Yes, we
Yes.
would
Does
request
she like that
a
necklace?
specific definition of the term false imprisonment based on the case law Proco versus state, if I may.
A definition of false imprisonment?
Yes.
The elements of it.
That, isn't that the elements of false imprisonment?
You have
Is the
8 months
definition
left,
of it?
Kim? So wait, so let me do the math. We're talking about April?
This just lays it out, Your Honor.
Okay. Let me just, oh, yeah, go ahead and take a look at it real quick, State.
Yes. No, it's kind of like raisins. I like raisins. I just don't like them mixed into things. Except for a cinnamon raisin bagel. But we went over that yesterday. All right. Colleen really loves nuts.
All right, did you want to be heard on this?
But we object.
All
I
right.
think the elements are sufficient.
Any further arguments?
No, sir.
All right. I see where you pulled case law that defines and explains some of the factual scenarios that have been presented in various cases and whether those meant or equated to or violated the false imprisonment statute. But I don't think I would give a definition of false imprisonment in the false imprisonment instruction. It's false imprisonment, then you explain the elements, and then both sides can certainly argue whether those acts were or were not violative of false imprisonment. Do you want this one, Mark?
Please.
All right, so let me do this. Same thing, it's just my marked up version that I'm going to give them so they can, that way the typeface will all be the same. Thank you. For
Thank you.
instruction in false. Put this.
Well, Kim, to get you caught up, how do you feel about avocado and cilantro? As long as we're on the subject.
How about aggravated battery next? I'm trying to take them in some semblance of descending order. Might not be perfect, but all right. Ag bat. So I guess what I'm looking for defense
I'm
from
not sure.
you is what parts or portions of aggravated battery
What happened
8.4
to
you're
their
asking
number?
for. It would start with Doug Benefield, A or B under number 1.
Judge, I think frankly, after reviewing this.
But they also have the
Okay.
the victim
So
and the
Agbat is
defendant had a daughter
withdrawn.
too, who's like
Next one is felony
about
battery,
7 now, right?
8.5.
Yeah, if she's found not guilty, there shouldn't be any.
Yeah, we're gonna withdraw that.
Yeah, there really shouldn't be any obstacle.
All right,
to her
felony battery
full custody
is
of the minor
withdrawn
daughter.
as a forcible felony. And the final one that you had requested was 8.2 aggravated assault.
Which daughter?
While there's a brief break, everybody check your phones, make sure they're on silent or
Okay.
turned off.
This
please.
one, I think, is viable.
You want to keep?
Yes, sir.
Oh, really?
All right. And so let's
So
look.
like 7.
There are some
or something?
options, so let me go through them. So 1 is standard, 2 is standard, 3 is standard, but then under 4,
She's out there.
are you asking for A or B?
B.
And what is the felony charged? The assault was made with a fully formed conscious intent to commit.
I think false imprisonment, Your Honor. Give me just a moment. I'm considering whether it would also establish any of the others.
The minor daughter, I have no idea who has
False
custody.
imprisonment.
I assume
Sir?
the defendant
False imprisonment.
Okay.
should. She's out on bond. She's not in custody.
state?
It's the same argument. Well, it's a two-part argument, Judge. It's the same argument as to false imprisonment. I know you already were getting it, they're getting it, but I don't think that there's evidence that he made threats by word or act, I guess, other than "you're done," which the state would argue is ambiguous. At the time, the defendant appeared.
Oh my
Mr.
goodness!
Benefield
Just
gave
as you
a
thought this couldn't get any better,
I don't know
look
what that
who
means
we
for
have
this
here.
case, and the
Oh
defendant
my
created a
goodness!
well-founded fear of
A
violence
celebrity
about
sighting.
defense.
We
And
have
I think this is
Derek
self-defense
Clark from
argument
Body
that I
Sites.
think
Derek,
is
welcome.
indicative. But also to then say,
Hey, Ben, thanks for letting me know.
and to commit,
Oh, your
false
public here has
imprisonment
been
against her.
clamoring for
Their
you,
argument was just that he was already false
and
imprisoning her
they
when
want to know
he.
everything.
I just don't know how you would put this in there, Judge, because he was
Because
already
we have this
committing a false
defendant here.
imprisonment, and then
We've
when he
heard
made the threat, he was then fully informed to commit another false
she's
imprisonment. I just think
claiming
it's-
self-defense. She
it's
shot
circular,
her
and I'm not
her
sure that it will
husband,
make sense for the jury,
and
it's confusing.
she was. So we heard
Like most
this
of
guy
these
was
things, it becomes a
not
question
really
of fact.
physically abusive with her, but
And
very mentally.
not
Everything. He
prepared to
punched
say
a dog in front of
precisely
her.
when, given those
He,
facts and the
like,
fluidness
threw a
of
cat
the
down the stairs.
circumstances,
He shot
when,
holes in the
or-
ceiling of the
or for
house
that
and
matter,
everything.
if the jury
And
will
anyway,
conclude that there was
but she's
false
been sitting here
imprisonment.
looking. She's a
All
ballerina.
right, thank you both
She's
very
been
much. I'll give it.
Here, let's see. When
The
they
question
show
is,
her,
any other portions of that, or it's just the elements of that one?
that's why I'm kind of. She's been having this
Certainly
sort of
there's no
sad
deadly weapon.
dog face looking. Very. She's looked very plain this whole time, and I don't know.
I think
There's a way to tell if
the
someone
first one, the
is.
circumstances were
I don't
such
know what
that
is
should be a
affect for
deadly weapon
the
is
jurors, if it's real or if it's contrived. I don't know.
valid, as would be
We need a body
not
language expert, and we
designed
couldn't think
to
of a
inflict
better
bodily
one.
harm.
But now they got to show. Come on, Court
With
TV.
her, like in the very beginning, she had her
Bodily
hand
harm is out.
covering her, like just the side of her neck, the carotid artery,
Okay,
Um,
and
which
And
just
that
As
is-
would be,
just means that she feels very vulnerable.
hang on, her lawyer's talking. Hey, lawyer Derek's talking. She feels vulnerable.
Yeah, I mean she's protecting one of the more vulnerable spots of your body. Before that was she's not doing it now. She's just looking down now, but
I see. So
There's a lot of
protecting
things
carotid
going on.
artery.
a lot of things going on in her head
With
with the she has a lot of blinking, like it just means that she's processing a lot of things right now.
Wordness, imminent commission of.
Really?
Forcible or burglary, comma, false imprisonment.
And I'm sure there's a lot of information that she has to process, but when you're more comfortable and relaxed, then your blink rate is slower.
Okay. What about anything about her? I don't know. Is there her eye movements or anything?
Nothing really. I mean, I'm sure that there's things going on, but just
So I think
look at the blink rate there.
I'm looking at it.
it would need to say
Usually a relaxed person,
imminent death
One-
or
Oh, yeah.
bodily harm to
like
herself.
it's going to be maybe
or the
3 or 4
imminent
times in a
commission
minute.
Of burglary, false imprisonment, or aggravated assault against herself. It'd be in the disjunctive. And then immediately after that, I'll need.
She does have one shoulder
Thank you.
lowered, so it's kind of that's another vulnerable.
All right, the next portion of what we need to
Position.
discuss on the self-defense, we're still on 3.6F. We're through the
It's what now? Having one shoulder
use of force
higher
in
or
the
lower
home.
than the other?
Well, yeah, I mean, because
Very
she's
next
so if I'm
paragraph talks
kinda
about
sagging the shoulder, it's
72.02. This is the
probably
bottom second page
because
of the
she's
state's-
resting
I think it's on the bottom of the
uh,
second page.
on an arm or something.
Interesting.
I think we talked about yesterday removing that, but let me make sure. The portion about
Any truth to that? That
72.02,
she's secretly sending messages to Griggsy, one of our chat members.
Maybe.
I think I already took it out.
Did we look at the blink rate? Maybe
I
it's
thought we
Morse
did,
code.
but I have a question mark next to the one on my copy,
Oh, okay.
so I'm just making sure.
It could be Morse code.
Could be Morse code, but if she's been in an abusive relationship though, then she's going to be like used to being vulnerable, and that may be more. Essentially, like you're in trial here, and that's going to make anyone nervous.
Right.
So, I mean, it doesn't necessarily mean anything. It's just something that to notice right away to see what,
thought you had asked yesterday if we wanted A and B. You said
to see
yes.
what it, just to be aware of
Oh,
that. That's
which
what
one?
right
I'm
now.
talking about the
Might
portion
be
that was
when there's
782.02.
Great.
And like the state said, I have it, we weren't gonna give it, but then I have a question mark by it, so that makes me wonder if it was, we're not gonna give it, but we're gonna think about it.
Anything from the judge there?
I marked it out, I have it.
I mean, it's hard to
think
tell
that's what it is.
Yeah.
This could be
Just
just
'cause,
me
like,
having a
like a-
question mark there,
without
for-
seeing what he was doing before.
but I just wanna get confirmation on the record that we're not giving it.
That right there is just anytime someone does any rubbing, then they're trying to ease, not necessarily tension, but just like just easing maybe the stress
Mhm.
of the case, or the maybe he's not sure about something.
So if her being scared and vulnerable, but you wouldn't be able to tell that necessarily from your body language. You can just tell.
Yeah, like that she's acting. Yeah, that right now she's displaying vulnerability, and she's displaying like there's a lot of things that she's processing. Now,
I like to have it.
that doesn't necessarily mean that she's, maybe she's acting, but usually with the blink rate, people
You're
don't
not gonna
necessarily, yeah, they
know that or not.
usually don't. I mean, it's possible that they study that kind of stuff, but the blink rate actually isn't one thing that she's going to want to show. Even at vulnerable, like even in vulnerability, like the covering up, maybe like that might be something that you could fake. The blink rate would be something more difficult to fake, because
Right, you
and you would
argument.
it makes you look like there's so much going on. Usually, sometimes when people lie, then they have an increased blink rate, or
Mhm.
when they're trying to think of the exact words to say, they'll have an increased blink rate. Or just when there's a lot of information going on and they're trying to figure out what to do and what to say, you'll see that blink rate. You wouldn't necessarily want to fake that, because it does bring some things into question.
Well, look, we have a question here.
No, Your Honor.
When you're a body language expert, can you have a conversation without analyzing the other person? Can you turn it off?
I do it all the time, because it's mentally draining if you're doing it all the time. But if I notice something in particular,
So
then
Something jumps out at
before I go
you.
to the state,
yeah, then I start paying attention. But
my
otherwise,
question.
sometimes I just don't want to always be
if we're
analyzed.
giving 776013 that talks about the approved or
Yes, we
justified
had
use of deadly force when one is in their own home or in their own residence or dwelling house. Including, and I'm going to give to prevent the imminent death or great bodily harm to herself, the imminent commission of those forcible felonies that I'm allowing. What are we gaining by adding 782.02? It seems duplicative to me.
Judge Isman. Do you know that I was watching the Olympics last night,
It would be the first time that-
and did you know that they're held in Paris? But do you know where the surfing competition is? The surfing competition for the Paris Olympics is in Tahiti.
It's repeating.
Which,
But
yeah,
that's kind of off the coast, isn't it?
that's kind of far away from Paris.
Almost the exact.
Well, no, but I mean, but down. I mean, it's still in the.
Been a homicide.
I could be
No,
wrong.
this
but
is like
it's the Atlantic,
Tahiti's
right?
in the Pacific. No, it's in the
The
Pacific.
Pacific?
Yeah.
Why, man?
Yeah.
I'm not going to pick geography for 300, Alex.
Yeah, I guess not. But I'm like, what is going on here?
Well, is Tahiti like part of France?
Maybe it was probably. Maybe that's why
I
they're
think
doing
I've
it
shown
there.
that
I don't know.
I tend to
Plus, I don't know that
give
Paris has
instructions when
great
they're lawful. They're an accurate
beaches for
statement of the
surfing. I
law.
don't know.
The facts of the case support the giving of the
That's part of
instruction,
French Polynesia, apparently.
and it's necessary
There you
to
go.
explain or clarify an area of the law to the jury so that they can do their job. However, when you look at
Okay, see the
what's
shoulder?
being proposed
Uh-huh.
under 782,
Well, I mean, she
that
she
portion
doesn't
of the
have the
instruction,
confidence in,
it is-
you know, and
while a
I
different
mean,
order,
I'm sure she's
it's
nervous.
virtually
But she doesn't have
identical.
the confidence to
Subsection C
where
talks
it comes
about
up.
To sit up straight,
Yeah,
shoulders
commission
back.
of a felony
So the dip
upon
shoulder is
Ashley
what? Just
Benefield in a
just
dwelling
lack of
house in which
confidence.
she was present,
interesting.
and that is taken care of in the instruction we're giving from 776-0131. It starts, if Ashley Benefield was in a dwelling or residence in which she had a right to be, and then she's justified to use that deadly force to prevent the imminent commission of a forcible felony. So C is taken care of in what we're already given. And so is B, because it talks about committing a felony upon her, but doesn't talk about the dwelling house. So quite frankly,
How about that?
we're already giving that. That would
The
not
farthest they've
wouldn't
been.
just be duplicative, it would be the exact
And I
same
can't even remember.
instruction
There's
given twice.
in the 2028 Olympics in
776.013
Los Angeles.
subsection 1 covers all of the issues.
I
and
can't remember what
elements
events.
that
There are some events that are going to be held in Oklahoma City.
All right, the next one
because,
is then
of
in
course.
deciding whether Ashley Benefield was justified.
Just because I can't
Certainly
remember what
that's
events,
in.
but there are some events that are going to be held in Oklahoma City for the Los
maybe
Angeles Olympics. So
The cowboy
go figure.
roundup event.
Yes, is rodeo now an Olympic sport?
I think so.
And then
Oh, you know,
Discussed
yesterday we had some
yesterday,
song
all
dedications
of
for
that
this.
middle
We had
part is out.
"Careless Whisper" by Wham
and then the last portion.
because she's a ballerina and
Yes.
Okay.
she's never going to dance again because Guilty Feet have got no
They got no
rhythm.
rhythm.
But I know that you are quite the singer. If you'd like to
Which
regale us
paragraph?
with or "Tainted Love,"
We could do some
this was a
karaoke.
definitely toxic relationship. What?
We could do some karaoke after. I hate everything about you from Mr. Big.
Yes, we need some criminal karaoke here. Song
Who's-
dedications.
Who's criminal then?
What's a criminal case? Maybe I don't know. Once I ran to you, I run from you.
That totally reminds me of the remember when Levi's they did those commercials?
Yes.
They had the guy on the heart monitor.
Oh yeah, the
Beep,
music.
beep,
Doot, doot.
beep, beep. He's like, sometimes I feel
Well, I've got to
beep
run
beep.
away. I've got to. Oh wait, there's a trial going on here.
They may have
They get
already
their jury instructions.
ruled
for
on
that.
it. may have already ruled on it while we were singing karaoke's.
Yeah.
Those are proposals. We didn't strike, if you look at 3.6 as the Florida bar has it, it's a six,
But-
that's a proposal to the subcommittee.
So we would like the proposed language.
Okay. Oh, so is that just a memo that you wrote?
It's the commission, it was when they proposed instructions before.
Yeah.
they-
Aha,
This was.
Mr. Body Language Expert. How do we
So the
know she's
committee
just not a
proposed putting in
sloucher?
totality the
She's a
circumstances,
dancer.
but it wasn't adopted.
Posture's a big thing for her.
Okay, I got you.
We would object.
Object.
Aha, David.
Court's not
In
valid.
your face.
I'm
just kidding.
All right.
No,
Thank
I
you
mean,
very much for the argument.
I don't
think
know
the
what she
state
was like
jury instruction
before.
We're dealing with
Right.
But
adequately
but really
explains the law. It's not a misstatement. It's not going
she's
to mislead
clearly,
the jury
you
in any
know,
way.
I
So
would be nervous
I'm
to
not going to
be
add totality
in
of
that
the
position where she's
circumstances.
at right now.
The jury is
But it's
told
just-
you must
there's
consider
that
the
lack of
circumstances.
confidence. Now
that
she's
the
trying to
person
say something that
used.
was
So I think it's sufficient. So that remains. And then if you look, then all that middle part is out. and then it goes to,
Uh-oh.
if you find
You can
that
get posture corrector things on
Ashley Benefield, who
Amazon.
because
Those
of
little
prior
figure eight.
threats or difficulties.
Yeah, I mean, and it
Pull your
doesn't
shoulders back.
Reasonable grounds to believe.
it doesn't
Is that
necessarily
part?
mean guilt. It just means that she has lack of confidence. So like if people are saying something or they're trying to convince you, but they're they're not expressing themselves a little bit bigger, then they don't necessarily
Right, all that middle part
believe
is out, so it's gonna
what
go
it is.
from, you must,
or
look
they
at
don't
the
think
circumstances
they're
that she
going to
was
get you to
faced
believe
with,
what they're
and
saying.
then it has the part
Wait,
about.
say that again. You're cutting out a little
you
bit.
may consider and you should
So I mean,
consider
like
those prior threats
that
and
slouching
violence that she
and not
Mhm.
knew about and
large
was aware
posture
of.
when you're saying something where you're trying to be convincing. You either trying to then you're not you don't believe that other people are going to believe you, or you don't believe yourself.
Yes, sir.
Usually, and it doesn't. Everyone's a little bit different, so you're always going to want to follow up when you see that kind of stuff. You want to get to the bottom of why someone might. I mean, if she's a dancer and normally has like erect posture, then why is she leaning to one side now? I mean, in this particular, she's on trial, so it's understandable. I would be nervous, especially if I had killed my husband. Even in self-defense, because you're not going to know how it's going to turn out.
Right. You got 12 people that can't get out of jury duty.
Right.
And decide your
fate.
guilt or innocence.
Doug
Yes.
Benefield had committed an act of violence. They wanted to be acts of violence.
Oh, it does say or acts of violence on the standard, so we have no objection. I'll change it.
All right. Well, so do you want it to say an act or acts, or just committed acts?
Acts, ACTS, acts of violence, and you may
Acts.
consider
AX.
this rather than that.
No pun intended. For the
Acts of violence.
it was an act.
You wanted to say this fact instead of that fact?
That's the Lizzie Borden
Okay.
trial.
I don't know.
Plural as opposed to singular.
Sure.
That's fine, Judge.
All right. Anything else on 3.6F?
No.
State?
No.
Okay.
Thank you.
3.7. Any objection?
Just say
They're
no.
at 3.7. That means they're beyond Viva Las Vegas 2.0 because they're 3.7.
Sir, you're not right.
Well, one of these days we'll get there. Maybe. Maybe.
So if they let that happen.
Yes, Katie, sit up straight. Now you got me self-conscious here. I gotta correct my posture.
So that is something like while someone's on the stand, that's something that where they're normal, but then your line of questioning all of a sudden makes like a shoulder drop or
Where is that at?
creates a change of
right before a reasonable
things that we've
doubt is
seen
not
with her.
possible.
You're really looking for a change. So when you see those things, but except that she's still in that position, and she's very, very uncomfortable. I mean, I don't know,
3.7.
Right.
Which paragraph?
Um,
Sorry. Oh, okay.
she's frozen. Basically, have you ever seen like people give like they're giving a presentation or whatever, and they're kind of in the same spot, that frozen posture, because they don't want people to see them. So so she's got that lack of confidence where the shoulders down. Put yourself in a position. How comfortable is
Is that the only update?
Yeah.
And to hold it for a long time, and hold that uncomfortable position for a long time without moving. There's just a lot of stress with that, and she doesn't even notice she probably doesn't even notice that there is stress because.
Well, looking at that one.
Otherwise, if she was a little bit more relaxed, then she would
They've
realize
also added
the position is not comfortable to hold for a long.
Is this one of the ones that just came out? May
So,
or
I mean,
July.
you normally move, you switch positions when you're,
So if you look at
Right,
the standard, are you on the Florida Supreme Court website? Is that what you guys are looking at too? It also has an addition. See, right in the, about a third of the way down, the defendant is not required to present evidence or prove anything, which is what we've always had,
Right.
except for the defense of affirmative defense to the crime of relevant crime, as I previously explained to you.
I think that would apply. in this case.
Do you want to make an argument for or against defense?
Judge, would you mind if I printed while you're talking so that I can correct it for her?
Of course.
Okay. I just didn't want to be rude.
Yeah, so, you know, it's interesting, Judge, because
Yes, she's been like that.
self-defense is an affirmative.
see, and that's the problem with like just looking at
In
the
instruction, they
trial. It's
acknowledge that.
obvious
Mhm.
that she's going to have that stress and
Limit the
uncertainty,
instruction.
like anyone would,
There's a suggestion
you know, on
insanity,
trial for murder.
Unification,
Um,
and attempt.
It's, I mean, it's just, it's interesting to note that that's her go-to stress position.
No, I think that's confusing.
Yeah, interesting.
I wouldn't request that.
Yes, Leslie, it is a tedious process, but not.
This is interesting.
Really not
I'm not even
family-friendly.
aware of any case law interpreting,
So, Derek, what do you think about
Yes.
avocados? As long as we're
because it's interesting.
On the subject.
And
You
State,
like
I'm just gonna
avocado?
throw this out there.
You know what?
So
that's one of the,
certainly,
that's
it's an
kind of
accurate statement of the law.
acquired taste.
I think we can all agree on
I
that,
Judge.
right?
used to like
State has to
avocados
prove
when I was
beyond a-
younger,
well, first it's a prima
but
facie
my
case.
wife, being
Proof
from
beyond a
South
reasonable
America,
doubt.
we have
Then
avocados in the
there's
house
the,
all the time.
Preponderance of the evidence that
I get-
an
I get more
affirmative
used to it.
defense, and the
Okay.
It's still
defendant
not
has the burden of production
my
and persuasion
vegetable
on
of
him.
choice,
But then
but
the burden shifts
um,
back for the state
I
to prove beyond a
can eat
reasonable
it
doubt
now,
the
whereas
defendant doesn't.
before
Did
you
not
didn't
have
eat
to.
an avocado.
So
Interesting.
it's
I
interesting
couldn't even put
because
it in my
this
mouth.
addition
What about
says
cilantro?
not required, defendant not required.
Actually, I
to
do like
present evidence
cilantro.
or prove
It's
anything except for the
it adds
defense
like a
of,
tangy thing to my taco
but then
salad.
doesn't talk about that burden shifting. I don't know. I wasn't on the committee. I'm on a different committee, so I don't know how they, I mean, I understand explaining, well, the defendant does have some burden, but then not telling them that it's a preponderance of the evidence, more
All
likely
right.
than
Can you
not,
power
greater weight of the
top
evidence,
three,
whatever
ABBA
words they
songs
wanted
for
to
us?
use.
Can I
But
do
then the
what?
burden shifts back to the state to
Judge is
prove
too
beyond a
loud here.
reasonable doubt.
Power rank your top 3 ABBA songs for us.
So, do you want to be heard?
ABBA songs? Oh
yes,
man.
since jury instructions here are boring.
Oh jeez. So I mean, so I want to go with Dancing Queen as one, but I think it gets overplayed.
Okay.
I do like Fernando.
That was my number 1, by the way.
Those are your-
Don't let me influence you, but yes.
And oh geez, now I'm drawing a
I gotta
blank.
think of them. Well, we had, what was it?
I have to
don't
think
know.
of Mamma Mia.
Waterloo, Super Trooper, yeah.
Ooh, you know,
Mamma
actually,
Mia.
Waterloo.
We had
I-
yeah, now I'm blanking on.
I'm trying to go through the Mamma Mia.
All right.
The
Shows-
discography of ABBA.
And certainly.
But I do like
After I
Waterloo
read
and
the
Fernando
instructions and I charge the
and
jury,
Dancing Queen.
I'll obviously
Yeah,
ask.
those are gonna be my top
objections to
3.
how the jury was charged.
Okay.
If it's just all the same previous objections, just renew your objections. Here's the reason I
that?
hesitate to give this right now. It's brand new,
A juror?
No, they wouldn't show jurors.
Oh, okay.
and I could be wrong,
Must be someone, a family member.
but I do have some
I think we'll have
concerns about
Rue McClanahan play
how
her in the
truncated it
made-for-TV
is.
movie.
with the actual nuances of the burden shifting that goes along with affirmative defenses.
Now we're talking about burden
And not
shifting.
explaining that. So I would feel some compunction if I were going to give this new portion of this instruction to explain that. At the end of the day, though, and remember, where am I getting to? So I could take that path with this new instruction, but going this way with just giving the instruction how it's always been, at the end of the day, the jury still has to find that the state has proven beyond a reasonable doubt the defendant's guilt and proven beyond a reasonable doubt the defendant is not entitled to. So I appreciate everybody's arguments. I could be wrong, and I'll let somebody else get the case law on how this instruction is going to work now.
Well, that's
So
right. We
let's
did already
I'm going to leave it
cast
at the
Judi
defendant is not
Dench in
required
that
to
role
present
of
evidence or prove anything.
woman in the.
You added in
the
that additional
gallery.
sentence,
There she
proof
is.
beyond a reasonable doubt does not mean beyond all doubt.
Oh, I'm sorry, Judge, so you're gonna put a period after the defendant is not required to present evidence, or you're just putting a period there and leaving the rest out?
Yes, leave the standard that is the standard in my mind.
Yes, sir.
And then you added in that sentence at the beginning of the,
I printed out a new one for her,
Perfect.
yes.
any other changes?
No, sir.
State? 3.7 good,
No, nothing else,
except for the objections about,
yes.
that'll be interesting to see how that plays out. All right, 3.9.
No objection.
All right, perfect.
Still
Again,
frozen.
that's where I'm gonna stop and then explain to the jury the verdict form. Any objection to 3.10?
No.
No objection. Yes, keep going. Good job.
3.11,
No.
Ooh, now we're moving.
3.12,
No.
Fantastic. Look at this. We got momentum going.
3.13,
This is a good thing. Yeah, when you see like they go through all these things and there's no objections.
Yes, because then we get to closing arguments.
During
That's
that
what
same
I'm curious.
paragraph,
I
I
want to hear the.
I'm so sorry. That same paragraph about during the trial, items were received, they'll be sent back. I do ad lib at that point because we have a tech cart that's right out here in the hallway. And when they go back to deliberate, they can play is it just the 911 call? Is that the only thing that's in?
Well, there is a DVD of text messages.
I don't know. I don't know.
They have a computer back there that has no access to the internet. It's just
like
a
normally, but
laptop that is on the tech cart that they can
possibly
use to view items or listen to
recently.
items. So I do go off
Wait,
script there to tell them
Sorry,
that.
judge is talking too loud. When she was
Also,
touching
up a
her
couple
eyes or
of
something.
No,
paragraphs,
she's
I
had
talk
bags under her
about
eyes.
cell
So it
phones
looks like she
have
hasn't
to
slept
be-
in a while.
Electronic devices have to be
Well.
left out. I also talk
Yeah, I
about
have noticed that.
smartwatches that can independently and separately communicate with the internet outside of Bluetoothing with another device, and that they have to leave their smartwatches with the deputy.
Welcome, June.
All right, and then the verdict form.
June is joining us from England. Derek, do you know what they call popsicles in England?
No objection.
I do not.
Would you hazard a guess?
On the manslaughter, I thought
Well, they
the
call
manslaughter was
Well,
just
graham crackers digestive biscuits, which is just
yeah.
horrible.
I think the manslaughter.
They need to
might
rethink
be-
that.
Sometimes
It's just one question, right?
But we learned that yes, over in England, popsicles are called ice lollies.
I think it.
Right.
Ice lollies.
This is the jury instruction.
Yes,
I've
an ice
Pops.
lolly.
June says June says ice pops.
because
Ice
I think
pops.
that
I thought we had
it-
ice lollies.
I think it puts too much emphasis on the separate charges if you break them up, and I think if they checked manslaughter. and
There we go.
one,
Thank
two,
you.
and
Ice
three, there's
lollies.
No harm. We just ignore 2 and 3.
All right. Do you want to be heard on that? Because the factual findings are different between obviously the second degree murder and the manslaughter for the
Yes.
sentencing
Would you be
enhancements and
more
the
inclined to
10/20
eat
life.
s'mores if you ate them with
I don't
digestive
have a
biscuits?
You're okay with
It
this
makes
one?
it sound
All right,
healthy.
They
here
call
we go.
graham crackers digestive biscuits.
They sound healthier.
Not a problem if nobody objects. Well, if there's nothing else, then I'm going to let you all go. It's right about 10:30, so that'll give you 2 full hours. If you could, though, be back, maybe 12:25, 12:20, 12:25, so we can get the courtroom all set. Everybody can be ready to go. I can get the jury up here, and we can get started.
Oh, wait, I'm getting some nuance here. An ice pop is a rectangle of plastic filled with the liquid you freeze.
Oh, did you want to make one now, or do you want to wait until the?
And an ice
after
lolly
we let the jury
is
go.
What?
After you let me go.
All right.
That's
So the
like
reserve on that.
like when we were kids, you take the ice tray and you put
Yes, a toothpick or whatever. Uh-huh.
yeah.
All right, y'all. We'll see you back in a little bit.
Thank you.
All right, well, Ben, I have to break out of here. I know they're going on break.
Well, hey, thank you for coming and sharing your insights and expertise. You're welcome back anytime. Your public was clamoring for you and your insight because we didn't know what to make of anything.
Yeah, I mean, I like if you're looking to see if she's faking it for the the crowd. I don't know. I'm saying like she's highly stressed right now because of it's natural to feel that way, but those are things.
Yeah, I mean,
Even when
she's
someone's
gonna
on
know
trial
she's gonna go to prison for
for a long
years
time.
and years, or she's gonna walk out free. So yeah. So yes, when you have a chance and you go look back at the prosecutor,
I'd have to
let us know.
see, but look, okay, wow, she's still like leaning to the side, and so that holding on to the arm like that, like very uncomfortable and very what do you call it? Like just lack of confidence,
Really? Just
feeling
not-
very vulnerable. Yeah, but look how tight she's clamping onto that arm. That arm. That's interesting that she still is dropping that shoulder.
I think so too. I didn't even notice.
Yeah, I don't know how if she's normally like that, but it's like there's like she's pulling the arm down with the grasp, but wow. Well, I do need to go though.
All right, hey, thank you. I appreciate you popping in there and
Thanks for letting me
indulging us and allowing us to use your expertise, man. Appreciate it. All right.
Okay. Well, you take it easy, Ben, and
All right. We'll see you
everyone
later.
Las Vegas.
Well, you're welcome back. Yeah, if you get another chance, this might go on for a while. So if you have more free time, feel free to join us again.
Okay.
All right, buddy. All right. Thanks, man.
I see it.
All right. There you have it. She put her hand over her carotid artery and dropped her shoulder. Who knew? Who knew? Kim, I have no idea what her bail. I just know she's out on bail. I don't know what it was set up or what she paid. Does anyone know? Yeah. Unless it says $100,000. She's out on $100,000 bail. Wow. Oops, there you go. Yes, 100,000. All right, that's the. Yeah, no, that's he always is interesting, and it is. Yes, you do get self-conscious around him. You know, because yeah, it's like, what is he? Oh, she has a curfew and an ankle monitor. I wonder what her curfew is. All right, hang on 1 second. I will be right back, everybody. Okay, I'm back. Oh, we got the Cork TV. Smooth jazz, or whatever this is, playing here in the background. So yeah, sorry about that. Oh, did Kim leave? All right. I had to check and see if my soap had arrived. You know, the soap we looked at yesterday. Only three washes. And the Magic Voodoo just, So I had to see if that had arrived. But sadly, it hasn't. So no Magic Voodoo soap has arrived. Oh well. Oh well. But now, no, I did not seriously buy it. I'm too cheap. I can give everyone my PO box if you'd like to buy it for me. Spend $29.99 marked down from $72 and buy the Magic Voodoo soap there. Actually, I was looking on Amazon. I think this is going to be my next purchase because, wait, can you even see that? The Rocktopus. Look at that. It's biodegradable PLA plastic. It's the head of the rock. If you can see that. On like with 8 octopus legs. So if you ever wondered, like, what would the rock look like as an octopus? Like if you just had the rock's head and octopus arms, that's what it would look like. And it gets 3 stars. Let's see. Reviewed this. 3 stars. It was breaking off. Its tentacles were breaking off, so I don't believe I can return it in this shape. Broken, 1 star. Unfortunately, this item came in the mail today, and 3 of the legs were broken off. Well, let's just see the rest of the reviews there. 5. Well, who gave it 5 stars? I mean, they just didn't write anything about it. So, whoa. What the heck just happened here? Where are we going? Yes. So, I think, oh my goodness. So, you know. So yes, go ahead and buy me the soap and I will try it out. I will try out the soap and see the magic soap cover voodoo. Or if you don't want to buy me soap, you can don't buy a broken rocktopus. No, I don't want a broken rocktopus. If you're gonna get a rocktopus, it can't be broken. It just I mean that's what good is that? What good is a broken rocktopus? However, in soap versus rocktopus, rocktopus wins. Okay. I could see that. But the rocktopus won't magically, take out the gray out of your beard and your hair there. See on the sides here. Stick that soap 3 times. Second time, third time, you're like, whoa. Where's your dad? Is he here? That's what you're gonna say. They're gonna steal my money. No, hopefully they're gonna steal your money. So I'm gonna try and talk some sucker into buying me that voodoo soap there. And then I will use it, we'll show you. I'll have a little playlist there of 3 times and you'll see the before and after. Well, you saw those before and after pictures I showed you yesterday. No. No, don't buy the soap. Yes, it's just like QVC. Good morning, Natalie. What do you think is better, magic voodoo soap or a rocktopus? Sorry to put you on the spot right as you walk in, but there is the rocktopus, in case you don't know what a rocktopus is. It's a 5-inch by 5-inch rocktopus articulated 3D printed desk decoration, office decor, dad gift, 3D model. And yeah. Let's see. And it gets 3 stars and 1 star. That soap got a lot of stars. We read the reviews, for crying out loud. Yes, and that was disappointing too. We learned they celebrate, yes, Rocktoberfest. Is that going to be in September also? All right, here you go. If you've got more dollars than cents, you can get lightsaber chopsticks. Okay, so if the rocktopus is better than the voodoo soap, how does a rocktopus match up with lightsaber chopsticks? LED glowing lightsaber Star Wars chopsticks. Reusable sushi light up. Set of 1 blue pair. Blue, that's the Jedis, right? The Jedis there. Look at her. Just look at the look on her face there, will you? Oh my goodness gracious. Look at just the sheer joy. Look at that. Look at that. Are you kidding me? How much joy. Imagine if she had voodoo soap, what the look on her face would be like. She's got her magic chopsticks there, gonna eat her sushi. Oh, look at that. Look at that. Look at that. Look at that. Light up. Oh, date night, huh? With light up chopsticks. Am I right? Okay, this might be better than octopus. I don't know. Okay, here's what's included. Easy to clean blades. Oh, look at that. 3 replaceable LR41 batteries. Well, you want to have the replaceable batteries. Pull tabs for battery life protection and a light up button. Look at that. Look at that. Look at that. Are you kidding me? Chop sabers and all that is included. I don't know about the creepy. Does that make you more likely or less likely to want to buy these? You know what would do that? Soap. Voodoo soap would just scrub the devil right out of her. Are we looking for a present? Yeah, I don't know. We're just killing time since my beard soap, whatever the soap hasn't arrived yet that we looked at yesterday. So we're looking at alternatives, and we found the lightsaber chopsticks, and this girl just loves them. Yes, Mean John. Which do you like better? Chopsticks or Rocktopus? For those of you, I know people come in and out, but there is the Rocktopus right there. 5x5 octopus with the. Oops, what did I just do? There's the head of the rock with octopus arms. Look at that. Look at that. Or you can get lightsaber chopsticks with this, and this girl loves them. Just look at her, man. Right there. Lightsaber chopsticks to eat your sushi with only $9.97. Less than $10. You can have lightsaber chopsticks. But I'm a little concerned because like if you touch that part, like see, don't you like wouldn't that chop your thumb off? Just saying. The Rocktopus is $12.99. Rocktopus all the way. You're gonna buy chopsticks, Natalie? What about the Rocktopus? Am I right, David? Yes, at that price, you'd be crazy not to buy them. You would be crazy not to buy them. Oh, wait, hang on. Wait a minute. No. Well, wait, Julia, you have those chopsticks already? Okay, and they are sweet. How many pairs do you have, Julia? And do you ever do a little date night? Yeah. Now she's got red chopsticks. Isn't that like Darth Vader? Isn't it the dark side? Don't they have the red lightsabers? Help me out. Do I have Star Wars people here? You know, I've seen the movies, but I'm not like. So Julia, yeah, ever do that there with a nice sushi and your adult beverages and your lightsaber chopsticks and feeding? She is evil. Should be a red flag, dude. Tell that guy he should run. Oh, maybe she's just accessorizing. She's not evil. She's just, she just wants to match her dress. She's a Sith Lord. Blue, green, yellow, purple equals good. Oh, yeah. Samuel L. Jackson had the purple lightsaber, didn't he? How could you have no dates? If you have 2 pairs of these, you should be like, you should be living it up. Are they lying to us through an advertisement? I didn't even think of that, Katie. Is she lulling us into a... So, there you go. But I got more here. Now, here you go. Now, this one right here. This right here. Let me move out to the side here so you guys can fully comprehend this. This is 3D funny shoe charms, big toe charms. Oh, look, some of them have hair on them. Can you see that? Look at that. And you can add those to your Crocs. Look at that. Oh, my goodness. Okay. Yes. See, it's the little details that count. And the good thing is, if those hairs on those big toes go gray, you got voodoo soap there that can. All right. So yes, look at that. See, you got, all those little things that you add on for your, your Crocs. Oh, look at that. Can you see the detail there? Look at that attention to detail. Where else are you going to find that? 3D funny to show. Yes. That is a must-have for all your Crocs. Are you kidding me? Look at that. Imagine being high and seeing these in person. Yes. Because I know I've been thinking like, man, you know what my Crocs need? They need a funny big toe charm. Look at that. So you buy enough of them and you're like, okay, let's. Oh, look, people actually bought these. Look at this. This is not a hairy toe. There are some weird lines across the nail. I expected more, but hey, it's a gagged gift. That was from Amanda Perry. Oh yeah, see, look, the toe comes in a nice package. And there it is. I guess, what is that, against a coffee mug or something there? Or, oh no, one house plant from, okay. So she gave it 2 stars because she was disappointed in the hairy toe. Rachel B, she was only 1 toe. I was under the impression that I would receive 5 toes. All I got was 1 toe. What good is 1 toe? Am I right, people? What good is 1 toe? Let's see. Okay, Terry gave it 3 stars. Small. Smaller than they look. Toes might work okay for kid Crocs, but not for adults. Croc toes. Grandson said these toes didn't stay in and they would go crooked, so he isn't using them. What an ungrateful grandkid. Maybe they would work if you had smaller holes in the Crocs. I don't know. Not worth the money to us. We already read Amanda Perry. Croc toes. Croc toe. Regina there. 1 star. Wasn't impressed. Missing ties and broke apart. Okay, Kenzie. Look at this. Kenzie gave us 5 stars. Look at these toesies. These are really good looking toes. My only thing is that there's only the big toe, so I'm stuck with 10 big toes. I request more varieties in skin tones and types of toes, please, and thank you. I think she's got a point, because if you just go with this look here, an all big toes. It should have the, where'd I go? Come on, Amazon. All right. Yeah, you should have a big toe and then this one went to market and eeny meeny meeny all the way home. You need all the toes. So okay, so would you rather have a roctopus? Would you rather have lightsaber chopsticks or big toe Croc accessories? Yeah. Yeah, I thought about that. But hey, this is the price I pay. It's the price I pay for good content while Ashley Benefield is on a break. Bet I saw what you did there. Oh dear. So, that soap isn't looking so bad now, is it? Is it? Are there any pictures that people posted of the roctopus? Are you seriously considering buying a roctopus? Let's see. Usually that comes with the ratings. No, I don't see any photos here of the roctopus other than just what they've got here. Got him looking there. Ooh, now he's looking the other side. He's looking straight at you, looking straight through your soul. And then at a 3/4 angle there. That's all we got there for the roctopus. $12.99 plus $4.99 delivery. You can have it tomorrow if you order within 5 hours and 16 minutes. But come on, you guys love the toes. Ads for word art. It's because I live, laugh, and love. Okay. But wait, see? I keep searching. Look at that. Look at this. See? I found one cheaper for you, $8.99. Oh, with $6 delivery. It's still cheaper. Oh, look, and it has a variety of colors. Oh, yeah, you can see. Oh, wow. Yeah, look at that. Look at that. Look at this octopus. It's great. Oh, look at that. You have your colors of, oh my goodness. A black, a blue, glow in the dark. Oh, folks, this is a great time to be alive. Gold octopus, gray, purple, red, silk green, not just green, silk green, silver. Oh my goodness. Wait, where's that other tab with the dude? You are done, man. I'm not messing with that other octopus. Look at look, and you can get varieties. You can have them fight each other, or they can team up and be superheroes. Oh my goodness gracious. Are you kidding me? Look at that. Oh, that's a pink one. A pink octopus. My goodness gracious. Yes, 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 yes. That's what I'm saying. Collect the whole set. When you're out and about today, if you see a veteran, be sure to thank them and say, thank you for your service, because we live in a country where we can buy a octopus. We can buy a glow-in-the-dark octopus. I mean, am I right? Am I right? Yes. I didn't even think about that. You can have your whole octopus army just sitting there staring, protecting your home, while you are out and about walking in your Crocs with big toes sticking out. Yes, the octopus. Good morning, Karen. We're just doing a little shopping here. You know what? Maybe I should. I should open a booth at the State Fair of Texas and sell nothing but, what's the plural of octopus? Would it be octopi? Nothing but octopi. And people will love it. There will be a line. There will be an orderly queue forming from my booth to buy a octopus in various colors. They would sell. Oh, they would sell. You were talking about the toes? I should sell toes. See, I think I'm with Julia. I think octopi, octopuses, a bunch of whatever. Both would sell. Well, maybe I'll sell both at my booth there. Yes. Yes. Why limit myself? Why limit myself? So, yeah. Oh, look, see up in the upper corner there? It says handmade products. Does 3D printed count as handmade? And does The Rock get any royalties from this? Is he okay with this? Like, why wasn't he sued to shut these down? Oh my goodness, Maria. This is how revolutions are started. Yes. Way to think outside the box. A toe-to-puss. Tentacle in the toes. Oh my goodness. Yes. 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 I love it. Yes. You know, at the maybe I'll have tentacles that will also stick out of the Crocs. Got a lot of work to do. Good morning, Beach. Just doing a little Amazon shopping while they're on a break. We had a no-go on the well, let's say my soap from yesterday didn't. Yes, you are nothing if not an innovator. Toad to puss. I like it. I like it. We need to workshop the name. But yes. Yes. I like it. What? Jenny, where are your priorities? Come on, I have more products to share. So be sure to come back and catch up. Because I think our next one is a winner. Okay? Forget everything you know about voodoo soap, lightsabers, big toe croc accessories, and rock pie, because we now have a cat butt tissue dispenser. Yeah, Katie, I'm glad you asked. Yes, we're going to make millions. But are you kidding me? Ooh, where'd it go? Look at that. A cat. And you pull tissues out from its keister there. Look at that. It fits square tissue boxes. Pull here with an arrow to the tissue. Oh my goodness. Oh my goodness gracious. Yes. Oh, there's the back view. There you go. All right. Have you ever I want to dispense my tissues, but I just have this boring box that it comes in. Not anymore. $50. Yes, it's on sale, David. It is on sale. Oh, Maria, I saw what you did there. I saw, Kleenex. Wait, Kleenex Kitty. So, little rubber hairy toe things don't look so bad now, do they? Oh wait, yes, there's this one's $5 cheaper. We got but still the same butt tissue dispensing prowess. All of that, it couldn't be so easier. I mean, a glow in the dark octopus, and now you got an orange tabby cat square tissue box. Cute bathroom accessories. Ooh. Let's watch. Come on. Oh, come on. Let's start from the beginning here. Okay. Oh, look, the real cat even loves it. Oh my.
I want to show you something kind of weird that I found on Amazon. Wait,
Okay.
hold on. This. Wow. Check this out. It's actually a tissue holder for tissues. If you feeling the sneeze coming on, you just, yeah.
Just reach for the
I
cat's
don't know why
butt.
it exists, but I kind of love it. And Butterscotch does too. Okay, maybe not.
She
so
bought the
much.
$44 one though.
That's okay, Butterscotch. It's not real. It can't hurt you.
It can hurt you, Butterscotch. Yeah, Daisy's not sure about it either.
Oh my God.
Oh, look, more videos here. Oh my goodness.
It's a tissue holder.
You want to see my cat's ass?
So you gotta feed it.
You gotta
once in
feed
a while.
Oh my goodness. Oh, is this adorable? Thank you.
You're welcome. Isn't it cute?
I like the crap that comes out of it. It helps my nose. Oh my goodness.
Happy birthday.
Thank you.
All right. Well, June, I don't really know how to describe it, but yes, it's a sign of the apocalypse. A cat butt tissue dispenser. I don't know. I can't. So yeah, now that soap isn't looking so bad, is it now? Is it? I'm just gonna leave that there. And for $1, that's a $50 fancy pants accessory there. Look at that. Look at that. I am not losing my mind, June. I am perfectly sane. So yes, June, if you're there, okay, so you can buy, while we're shopping, we've got the cat tissue dispenser. We have light up Star Wars, whatever, chopsticks there, lightsaber chopsticks. We have 3D printed Rocktopus. So yes, your favorite Dwayne the Rock Johnson head on an octopus body, because why not? And there's a glow in the dark accessory. Wait, I'm sorry. I buried the lead there. Where was it? Yes. Glow in the dark. Glow in the dark, Rocktopus. And then I think the consensus favorite of everyone here and everyone is going out to buy right now is the toe, the hairy big toe accessories that only come in big toes. They don't come in the other little piggies are sold separately, apparently. But there you go, June. See, June gets it. The Rocktopus is awesome. The Rocktopus is awesome. So there you go. That's where we're at. They're on a break until, gosh, what? When are they coming back? I don't even know. Your son has a Loch Ness monster on his crock? All right. See, so like a big hairy toe wouldn't be too bad. $12:30 Eastern. What time is it now? Oh my goodness, 8:24. We have to do a lot of shopping. But I've got more. I've got more. Are you ready? You ready to see one more? I'll take that silence as a yes. We want to see more things that we can buy. And there you go. The Prank Pack Pet Butler gift box. Look at that. What fits a small sweater? The Pet Butler. It's just a prank. Video's lame. It's a serving vest for animals. See, so put your pets to work. Look at this. See, the hairless cat there comes with strawberries. See, and look at this. Look at this good dog. And bring you. Oh, would you like some crackers and some crudité? Yes, yes. I've got you your favorite cheeses because you power rank the cheeses. What a good boy. What a good doggy. Look at that. Look how happy he looks, kind of. So there you go. Put your pets to work for you. Look at that. Yeah, have your hairless cat serve you strawberries. Mm-hmm. Be a good dog. Look at that. At parties, I mean, who wouldn't love to eat cheese and crackers and crudité off the back of your dog? Well, get him the pet butler, and he will not fall over. Yes, the happiness on that dog's face. Look at him. Look at that. He's just happy to serve, happy to help. Let's see. So what's included inside there? Oh, look, there's what is that? It's the thing. I guess you just stick. See, so you can stick your serving tray on the back. Oh yeah. And your hairless cat. What was Dr. Evil's cat's name? It was the hairless cat. Because your dog wants to please you. That's why. So he won't let it fall. He knows. He knows. Your dog loves you and he wants to make you happy, so he won't let it fall. That's why. Mr. Bigglesworth, that's right. That makes me angry. When Dr. Evil gets angry, Mr. Bigglesworth gets upset. And when Mr. Bigglesworth gets upset, what do you mean? They got a picture, Kel. Right there. Look at that. The hairless cat serving strawberries. Are you saying that you don't eat your strawberries off the back of a hairless cat? Bravo, David Franklin, for knowing your Austin Powers reference there. So there you have it. My birthday is coming up in September. And there you go. Pet butler. A cat butt tissue dispenser. Lightsaber chopsticks that this girl just loves. Look at that. You thought the look on that dog's face was precious. Oh my goodness. Who doesn't love lightsaber chopsticks? I mean, how do you eat your sushi, huh? Yeah. Glow in the dark octopus. Yes. In a variety of colors. Look at that. Look at that. You got to collect them all. And we've got two toe shoe charms. Read every word of what sentence? Yeah, are you kidding me? I would love to. No. Don't get me a cat butt tissue dispenser. Do not do that. Do not. But what I'm saying is my my soap yesterday doesn't look so bad now, does it? Does it? Does it now? All right. I will be right back. Talk amongst yourselves about what you want to buy. I'll leave this on just in case I'm not going to be on that. Yeah. Shop. Hello. So this is what happens when I'm gone. I can't leave you folks for 20 minutes without you talking about cat butts and addiction. So wait, is someone addicted to cat butts, or what exactly are we talking about? Yes, I did. I finished ordering my magic voodoo soap. And so, yes, you won't recognize me after 3 washes. Katie is addicted to cat butts. Oh, bravo. Bravo. See that, Colleen? Griggsy, our resident gourmand here, Swiss cheese on his ham sandwich. Oh, I see. So when I leave, we have like, you have mature grown-up conversations. Okay. Wait, Katie, what do you're making a crochet version of? My goodness, who are you? Who does that? Who adds caramelized onion jam to your sandwich? That does sound amazing, but yes. Are you really, Katie? Because Katie is a legendary crochet artist, right? World-class crochet. How would you describe your crochet skills, Katie? Legendary. Katie, do you have a store? Do you have like an Etsy store or something for all your crocheted wares? Wait, are you calling a Rocktopus weird? And the cat butt dispenser weird? I want to see weird. You should see the things I showed you that I didn't show you on Amazon. You sell in person. Okay, makes them more valuable and sought after. I get it. June, is that directed at Katie? Yes, ham and Swiss are just like, yes, the perfect combination. What? Okay, now we're getting somewhere. How would you crochet the rock's eyebrow for a rocktopus? Is that what you're thinking about? Sure, Griggsy. Do you have any in mind? Or we can go shopping and get some fish slippers. Look at those. Look at those. They come in all sorts of colors. Look at that. Look at that. So it's like a fish on its side. Your foot goes right inside there. Oh, look at that. That is a thing of beauty. Look at that. So many different colors to choose from. You can accessorize. Oh, look, a little goldfish. Oh my goodness. Look at that. Look at that. And there's the size chart with some Chinese or something. I don't know what that. Look at that. Look at that. Look at that. Hang on. Here we go. Can we see that? Can we zoom in over that? Casual boy. Yeah, these look like these come from China. So there you go. Whoa, 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 wait. Okay. You knew that fish slippers already existed? You knew that they were a thing? Hang on, wait. Oh, I can't get the link there. Hang on. It's a famous video? Let's see. I can't link it. Obviously. So I'm the one who's out of the loop. I'm the boorish oaf who didn't know about fish slippers. Look at that, man. So on the side, so the bottom are like so it was like the sole of its sole. So the bottom is just a fish, and then your foot goes in look at that. And Katie, you knew about this and didn't tell anyone? You didn't tell me? Oh my goodness. All right, let's see here. Let's mute the smooth jazz from Court TV. So, Griggs, is this what you want to share here? Is this what we're going to watch? Oh, is this? Oh, let's see. Oh, I thought we had action going on in the. Okay, let's.
Jeff Sokol thinks he's going to scarf down some pepperoni pizza with a 13-year-old girl he just met online. But tonight, he apparently has a different kind of topping in mind.
All right, I think we got. Oh, wait. We have some action going on here in the. All right. And I don't want to get a copyright strike, but there we go. We are heating back up here in court. Uh-oh, did I get a copyright strike? Oh dear.